Okay, thank you. Okay. The Town of Groton Planning and Zoning Commission is called to order. We'll have roll call. Hal,
Here.
Michael,
Here.
Steve,
Here.
Kevin,
Here.
and Lauren. All right, we have a public hearing tonight. How would you, is it possible for you to read the ad? The advertisement.
Notice is hereby given that the following public hearing will be held on September 23rd, 2025 at 7 p.m. in Community Room 2, Town Hall Annex 134 Groton Long Point Road, and virtually via the Zoom platform to hear the following. Special permit number 225-0002, 2041 Gold Star Highway, formerly known as Zero Yetter Road, PIN 27001562578, RU 40 zone. Renewal of special permit 321 for excavation, importation, processing, and sale of earth products, including periodic crushing operations. Review is per section 5.1-2.e and 9.4 of the zoning regulations. Frederick R. Whittle, second, William T. Whittle, deceased, and Willow Farm owner, Jeffrey Londrigan, Conway, Londrigan, Sheehan, and Monaco PC applicant. The Zoom meeting link will be posted to the town's website meeting calendar. Applications are on file and available for public inspection during normal business hours at the Planning Department, 134 Groton Long Point Road, Groton, Connecticut.
Hey, thank you, Al. Okay, at this time, would the applicant like to make a presentation?
All right. Good evening, everybody. For the record, my name is Jeffrey Londrigan with the law firm of Conway, Londrigan, Sheehan, and Monaco. And for the last 18 years, I've had the privilege of representing the Whittle family and Willow Spring Farms in a number of different capacities, but mostly with regard to the subject property and this application for a renewal. For the benefit of any new members who weren't here in 2022 or in 2019 or 2012, when we first came in, and back then you were just a zoning commission and not a combined planning and zoning commission. I just want to take a moment or two at the beginning here to go over sort of the process of where we've gotten to over the last 18 years. Back in 2007, the town zoning enforcement officer issued a cease and desist order to the Whittles. At the time, it was owned by three brothers, one of them being Rick Whittle's father, regarding the sand and gravel operation at the subject property. The ZEO at the time determined that the property was validly pre-existing non-conforming for the excavation and screening of the applicant's own rock, soil, and sand on the subject property, and it could sell its own material. But the ZEO determined that the property was not pre-existing non-conforming for importing material from off-site or from processing or crushing material from any source on-site or off-site. There was an appeal to the ZBA and subsequently to the Superior Court, and the Superior Court case was resolved in 2011 by way of a stipulated judgment, which I have a copy of here. I just have two exhibits, but I'll hold them until the end to present them, just for the record. The stipulation, in essence, gave the applicants the right to import material from offsite and to crush material from any source within certain parameters. And those parameters could be made more restrictive by the then zoning commission, now you, the Planning and Zoning Commission, as part of an application for a special use permit to conduct all four activities, the two pre-existing non-conforming activities, as well as the two that were covered by the ZBA stipulated judgment. So at the end of 2011, we make an application for and receive special use permit number 321 to conduct all four activities at the subject property. A neighbor at the time takes an appeal of the issuance of that special use permit. My clients take an appeal as well to preserve their rights. Those cases wind their way through the courts until 2015, when a resolution was reached in the neighbor's appeal, which was the Turner case versus the Zoning Commission. And my clients, that matter is withdrawn, and then my clients enter into a stipulated judgment with the town, basically making some modifications to the original special use permit number 321. In 2016, our clients go ahead and take care of all the preconditions of the special use permit. They put 60 acres of their land in conservation. They went around, and every 50 feet, they put a little placard that says that this is in, putting markers in for designation. They built a berm on top of a ridge on their property on the eastern side of the property to better insulate, block, and screen the neighbor to the east. They blocked off access road, one of their access roads on Yetta Road. They do all of this, and the special use application, or the special use permit, I should say, is finalized, and it goes into effect September of 2017, with the condition that we come back in 2 years for a renewal. So we come back in 2019, and it is renewed for this time 3 years. Under the special use permit, we had the discussion at the time. It says that our special use permit is subject to renewal every 2 years, but if you wanted to extend it longer, you had the right to. You exercised that right in 2019 and again in 2022 with a 3-year extension. And that's why we're here this evening. Our 3 years is up and we're back for another renewal, our third. So why do farmers need to have sand and gravel? For at least 4 generations of the Whittle family, the sand and gravel operation has been run at the subject property. And the reason for that is it's actually quite difficult to make a living just farming. And Rick is going to probably present and wow you with some special effects and show you why and how much goes into farming and creating produce. You cannot sell enough dollar cucumbers and ears of corn at the farm stand to make ends meet over the entire year. The income generated by the sand and gravel operation supplements the farming operation. It permits the Whittles to continue to farm their 300+ acres in town, including 5 acres that are on the subject property as well. And as we will address later this evening, many of the complaints we believe the town has received over the last several years, going back about a decade, are all related to noises coming from the farming operation that's happening on the subject property. There's 5 acres of corn and pumpkin patches and so forth and so on the site. Without the sand and gravel operation, the farm could not survive, just plain and simple. And 300 acres in Mystic would be sold off for development. My client recently has gotten an unsolicited offer from a national developer to buy all 300 acres and close the farm and set him up and his kids and his grandkids forever. My client has no interest in doing that. My client wants the farm until his last breath, the same way his dad did. So it's intrinsically important to the farming operation, this gravel pit, to allow them to farm and to continue to farm, that when we were asked by the commission to put 60 acres into a conservation restriction, they didn't blink and they did it. And we're happy to do so to continue with keeping our farm going. I'll tell you what I told the ZBA in 2007 and what I told the zoning commission in 2011 and this commission in 2019 and 2022. The Whittle family are farmers. They simply want to continue farming, and this gravel business helps them to support that and to do that. So the law. Apologies for sounding like an attorney more than I have to. I know you're all experienced commission members, but for purposes of creating the record on this application, allow me to state what I believe is a standard of law that applies. This is a renewal of a special use permit, the 3rd renewal of a special use permit originally granted over 12 years ago. And as such, the commission, you act in your administrative capacity rather than in your legislative capacity. And in your administrative capacity, when you've issued a special use permit or a renewal, when these types of applications are before you, your discretion is a bit restrained. You have already determined that the use can be done or the renewal is appropriate. And so long as we can demonstrate, hopefully to your satisfaction, that there has been no change in circumstances in the surrounding business or operations, your ability to deny our application is somewhat limited. And it's respectfully submitted that there's been no change substantially or otherwise in the condition of the property since initial approval in 2011, first renewal in 2019, or the renewal in 2022. To the extent that the sand and gravel business has remained constant over the last several years, as indicated in our supplemental narrative, the amount of material processed and sold over the last 3 years has been roughly the same that it was the 3 years before that, the 2 years before that, and the 6 years before that. The stockpiles are essentially in the same location. No interior changes have been made to the property as far as location of the cornfield, the pumpkin patch, the interior roads, everything's laid out the same. As a point of clarification, however, town staff reached out with a question about elevation shown on some of the stockpiles. In kind of going back, like I said earlier, we've been involved with this property for 18 years. In addition to losing some of the members of the Whittle family, we've actually had 4 different engineers and surveyors work with us over the years as they've come and gone and retired themselves. So for purposes of renewal permit 368, which was the first renewal that we came in on, there was a condition 1A that said that stockpile H, which was the unprocessed material, shall not exceed 201 feet elevation. Well, our original plan from 2011, done by DeCesar Bentley, identified the unprocessed stockpile as stockpile D/E. And then in 2019, Lorero did the plans and identified it as stockpile H, and that's when the condition came in. And then in 2022, not really catching this at the time, our second renewal, Mr. Dempsey identified the unprocessed material stockpile as stockpile F, as in Frank. And then this year, our new surveyor, Jim Bernardo, identified it as stockpile D, as in David. I guess that's a long-winded way of saying that stockpile D was formerly stockpile H, and so it is less than 201 feet, which is what was required under special permit 368. And I'm going to do my best to remember this next time we come forward to make sure that whoever our surveyor is, hopefully it's Mr. Bernardo for a while, rebrands stockpile H as the unprocessed stockpile so that it marries up with 368. So apologies for the little tangent, but I did want to address that just so there isn't any confusion. Again, no change in circumstances at the property. The temporary rock crusher, when it comes in, it's at the same location on the property. And we do have with one exception, which I'll get to in a minute, we're asking for nothing more than what we've had over the last 3 years as far as terms and conditions and restrictions. We want to keep the status quo and not do anything more than what we've already presently been given. The one exception is we would like your consideration in perhaps modifying the holidays when the gravel operation must be closed. In special permit 377, which was the one that was approved in 2022, the commission, there was some discussion about what are the proper holidays that should apply for when the operation is closed. And they were specifically listed in special permit 377. The 2 that my client would like you to consider perhaps alleviating them from are Good Friday and Veterans Day. And when I thought he was going to ask me for it, I thought the summer ones, because that's when everybody's doing work. But actually, the rhyme or reason behind Good Friday and Veterans Day is because construction companies happen to be open on those 2 days. They're not open really on Memorial Day or July 4th or Labor Day or Christmas Day or Thanksgiving. But they are open on Good Friday and Veterans Day. Those typically tend to be more workmen's holidays than anything else. There's still activity going. The stock market is open, those types of things. So my client would like to ask for your consideration in perhaps opening up just those 2 holidays in the list of ones where they could remain open. And I also want to address, because I know there are some revised plans that hopefully can be seen on the TV. One new item that was raised is about a new stockpile of stumps and leaves on the site. The reality is that stockpile of stumps and leaves has been there for decades, going back to Rick's father. But how it came about was a complaint was made to the town earlier this year about seeing that stockpile of natural material on the site. And I believe the town has come out and looked at it with my client It's essentially a pile of tree stumps and leaves. And what it's for is basically farmers have always been on the cutting edge of green efforts and recycling, and particularly in agriculture. And what they have done, the Whittles, over the years is they allow the tree stumps and the vegetation to naturally break down. And then that material is then used in the fields of the farm, for example, as mulch around apple trees. And I believe Rick is going to show you some pictures of that later on. So none of this natural material stockpile is being processed. I wouldn't categorize it, although Mr. Bernardo called it a compost heap. When I think compost, I think banana peels and eggshells and food more than anything else. This is really just the breaking down of trees and leaves and other items to be repurposed elsewhere on the farm. Our surveyor got the plans and he shows it there. We have no issues with obviously showing it on the plan. We had the cubic yardage of it identified and calculated. We're still well underneath the maximum that's permitted under our original special use permit 321 as far as stockpiling of material processed or unprocessed on the site. But a question was raised if this stockpile would be considered a composting facility for purposes of the Department of Energy and Environmental Protection. And in looking at their guidelines, my gut is telling me the answer is no. The material used each year is less than 5,000 cubic yards, and that's what triggers a permit up at deep as far as a composting facility. But it's also exclusively used on farm, which appears to be an agricultural exemption to the composting permitting requirement. But independent of that, we are speaking with DEEP. We're going to look to see what exactly has to happen. And we would agree that if you were to grant our application for renewal, making it a condition of any renewal that any DEEP approvals that might be necessary are obtained, we have no problem doing that. Again, we believe it might be much ado about nothing, but all of the use of this material that breaks down naturally appears to be outside of the DEEP jurisdiction for a composting facility. So that's the ask on our application. I'm going to take a minute just to sort of be proactive. We're aware that there have been complaints over the years from neighbors about this operation. And I guess you're going to hear more complaints this evening about this operation. It's a pre-existing non-conforming commercial operation in a residential zone, so there's going to be some friction. I will state, though, that in 2019 and 2022, when we were getting ready for our first renewal, the complaints started coming in closer to when our time to be here before you this in the evenings was occurring. And I'd also say that over the last 10 years, most of the complaints have really only come from one particular neighbor. I think the rest of the neighborhood that maybe showed up in 2011 has seen the benefit that this operation provides. I think over the years of our renewals, new permits and conditions have been put on, and I think they've been very instrumental in helping. For example, last time we were here in 2022, there was a complaint about an old-time customer who showed up at the site and who had not been at the subject property for years. And he came to deliver a load outside of the hours of operation, and he came in off of Yetter Road and not off the access way on Route 184. They didn't know about the special use permit that had come in 7 years earlier. Regardless, a condition from the last time we were here before you under permit number 377 was we had to put signage up to be installed to say basically that farm entrance only is at some of the locations on Yetter Road. And they're on both sides, no exit, and you have to turn around. And since that time, I don't think there's been a complaint about any trucks accidentally coming in off of Yetter Road. So over the course of time, as this renewal process and this operation and working with the town has gone along organically, I think a lot of the issues have been resolved for much of the rest of the neighborhood, but for one particular neighbor. As those complaints come in, the town reaches out to myself or my client. My client investigates it. They look at it. Almost every time it is where sound or noise is being attributed to the processing operation, when in fact it's related to the farming operation or the sale of the gravel and sand operation. But I give you my word, my client will always follow what the town comes with as far as complaints. He will investigate and do inspections. He welcomes inspections from the town because he knows that there's eyes on him waiting for a misstep, and the Whittles don't make a misstep. And every time that there's been complaints, they've been reasonably shown to be not related to a violation of the special use permit. Now, regarding complaints starting early before 8 a.m., it's important to note that our operation can begin at 7 a.m. It's 50 days a year that crushing must occur only between 8 and 4. But complaints about hearing trucks before 8 a.m. are not valid because we can start selling at 7 a.m. And also, we're going to hear a little bit tonight about honeybees and when you have to spray crops, and you have to do that at 5 a.m. And so there's a lot of noise that comes from this that is independent of anything under the special use permit. It's all under our pre-existing non-conforming uses and also the agricultural uses that are actively done on this site. So it's impossible to make everyone happy all the time. We understand that. But I'd also like to state for the record, and some of you I know have heard this the last 3-6 years, some of the stuff that my client has voluntarily taken care of in an effort to be respectful to the surrounding residential properties. There's no more recreational firearm target practice at the site. That was historically done about 15 years ago. The police had ruled the activity was legal and was creating friction. My client shut it down. There may have been one bachelor party for a relative this year where there was some shooting in the pit, but I promise you that's the only time it's happened in the last 15 years. We ceased using a bird cannon to protect the crops, not only on this site, but also the cornfield across the street. Again, this bird cannon would go off to scare the crows and the birds. Neighbors complained, we stopped doing it. My client realizes a loss of approximately 40% of the crops from these fields. He doesn't care. He does care. He doesn't mind. Additionally, we put in some buffering and screening to the east side. What was a 6-foot berm 15 years ago is now a 25-foot berm. We ceased using a sand screener that was on the east side of the property. It was used for 60 years up to 2011. They moved their screening operation into the pit closer to the west and away from the neighbors to the east. And although OSHA does come down and yell at him every now and then, Rick does try to limit the use of backup warnings on vehicles as best he can. OSHA does have some requirements that certain vehicles must have them, but that's always something that also the Whittles are looking at trying to avoid. So in conclusion, it's respectfully submitted that the renewal application be granted. There really have not been any changes in circumstances over the last 3 years. We obviously will take care of whatever DEEP's requirements are for the composting heap, for lack of a better term, and we would respectfully request some consideration on Good Friday and on Veterans Day. And other than that, I'll answer any questions anyone might have and just want to reserve a few minutes in rebuttal to address any other comments that are made by the public here this evening. Thank you.
Okay, thank you. At this point, staff, do you have anything you want to say?
Yeah, I just wanted to, like I said, I was gonna just hand out two exhibits. I just have a copy of the ZBA stipulated judgment from 2011. And I have a copy of the the zoning commission stipulated judgment from 2016 that I referenced in my comments, just to present them for the record. Nothing more than in the unlikely event that an appeal to the Superior Court follows. So if I could maybe submit those, and then I have nothing else. You wanna? Want to go later, but if you want to do one, just like that. Why don't you go?
We go public hearing.
Is that okay? Yeah, that's a good. We're gonna have extra.
Is this in our packet?
One of them is, one's
Okay.
not.
I
Well,
think
I'll
that's-
take them
The
both.
ZBA one, the ZBA one was in, this one was not.
So is the one not the 2011?
Yes.
Okay, that's what I haven't seen.
Thank you.
Thank you.
It's not on there.
Thank you.
Oh, it's not.
Thank you.
It's always on, Stein, that's always.
Hello, everybody. Most of you know me, I've been here before, some of you are new. So I'm gonna do a fairly quick and efficient kind of grassroots presentation. My name is Frederick Whittle, better known as Rick Whittle. I am the fourth generation on the farm. My son is the fifth, he is here. We love what we do. We both work 5 in the morning till 7 at night, 7 days a week for about 3 months and 3 weeks. It's a lot, but due to just the nature of what we do, there's really not much choice. So I just wanted to give you a little story about when you plant a seed, whether it be corn, beans, squash, otherwise. There's 8 steps. You gotta buy the seed, you gotta plant the seed, you gotta weed the seed, and you gotta fertilize the plant, you gotta spray the plant. You have to, like a year like this, irrigate the plant, which again, it's a lot of work. It's thousands of feet of pipe that come out of 4 carefully placed irrigation ponds that were dug literally by my grandfather 75, 80, 90 years ago. Then you have to harvest the produce, and you got to package and sell. And before all that happens, you have to buy the fertilizer, which due to the war in Ukraine and other factors is about $750 a ton. You got to buy the chemicals, which are literally thousands of dollars, which no one likes to use, but with the wet springs now, you have no choice because the chemicals are what defends the rotting, the molding. People always don't understand how they have natural protection. And the only way I can describe this is the spray is actually the condom to the rain. The rain is like the worst thing. And in the spring now, it rains every day. In fact, this year we probably had our worst apple crop in the over 100 years we've been there because there was no pollination, because it was like 45 degrees every day. The bees don't come out unless it's over 50 with the sun out. And it like rained 7 of the 10 days the blossoms were there. So there was terrible apples, and we have a decent pick your own operation, which is pretty much this year almost non-existent. So then on top of that, you got to pay the guys, the school kids, if you can keep them off their phone, 16 and change an hour. You got to pay the girls in the store the same. So after all of that, you're selling this for $1. So those 8 steps, fertilizer, chemicals, everything else, same thing. Your corn, we do sell a lot of it. People drive 9 minutes for it, but same exact thing. 8 steps to make it happen, chemicals, fertilizer. So long story short, the gravel pit subsidizes the farm. So Attorney Londrigan was saying it's 300 acres, it's actually 365. It's a beautiful place. It's the last commercial farm in Groton. I'm very proud of it. So there's that. And as far as he touched on the holiday schedule. So I just going to very quickly go through this with you. This was my facility on, this is, 4/18, so this would have been Good Friday. So my bank, probably a lot of your banks, is open on Good Friday. The stock market is also open, because it's a religious holiday. So I don't think small independent business should be punished for religious holidays. And I also wanted to bring you this for Veterans Day, and I can give one to everybody. Construction companies that we work with, work these days because there's minimal people, minimal traffic. And these are on your roads. This is West Mystic Avenue, a construction crew working. And I can't sell them anything, and they cannot dump anything because I have to be closed on that particular day. So they either have to stockpile on the road, which again, the town does not really let them do or want them to.
Thank you.
So this is the Veterans Day holiday, new water line that was being placed through the West Mystic area of town. Here's. So again, the two holidays, and the other bizarre thing is, there's really only three of us that do this. There's myself, there's the guy at the reservoir for 117, but that gravel is actually technically purchased from the city of Groton. And there's one over in Oakdale called the Bo Lombardi facility. They were all open on those days, which obviously I would rather not have my clientele going over there because they can't get into my facility. We also did, I don't know if you're familiar in Ledyard, they did a walkway from the high school to Ledyard Center. They called it the Ledyard Pathway. They were also working on Veterans Day. It's just to show you. Again, everyone needs supplies and it's hard to furnish them if you're not there. And I'm not, my attorney initially thought I was gonna ask for like 4th of July and Memorial Day because everyone's home looking for topsoil or whatever have you, but no, I don't mind trying to cook a hot dog that day myself. So these are just important days for companies that we work with. And let's see, I was gonna be quick this year, I promised everybody. And there was one more thing I wanted to go over. Yeah, so I know they're talking about this brush and leaf pile and stump pile. A lot of them come from when we have to strip back our land to sell the materials for these projects. So when we knock the tree down, cut the tree up, sell the tree for firewood, the stump has to go somewhere, but the long-term plan here is to make this area more farmland. As we lower it, flatten it, there's a water source. But we rent land from where the warehouses are up on Flanders Road. So we lose a little bit of land every year because they continue to build more warehouses. So that whole thing is rotting down to give us soil so we can cover this 15, 20 acres or whatever. I had this wild idea. There's great ice cold water that comes from there to maybe someday do spring water. And Deb said, another day. But the long-term plan though was either, pumpkin, sweet corn or something. So like I say, we're losing land from this commercial development. We initially rented like 10 acres from him, and I think now it's down to about 5. And the 60 some acres that we put into the conservation easement, that was commercial industrial land, which could have been a solar field for income. I could have done my own warehousing project, but I chose to put it into the protected easement so that we could continue to sell rocks and sand, which is what we like to do. And the only other thing I wanted to show you all is there's something that has come up, and I think it's something to do with the wording way back, is the concrete and asphalt that we get in. We get it from town projects, the pickleball court, hopefully you've all seen it. That was our material underneath. They dug it up, they brought the excess to us. But as far as the asphalt and concrete, they're trying to call it construction debris. So when you tore this building down, the roofing, the ceiling, the walls, carpeting, insulation, to me, that's construction debris. When you get to the concrete floor, that would be jackhammered up, brought to me, it would be processed, and then I have actually had it tested and it has now been for its DOT graded subgrade material under highways, roads. So I just wanted to show you the 4 steps, so you can see what actually happens with that, because it's not, we're actually recycling, we're a benefit. So this is how it starts. This was again, your project, when you're redoing some of your water lines, that's what comes out of the street. That's where it goes into the, this is where it comes out, all process, it's concrete, like I said, pass from DOT subgrade material, and then one more. This is where it gets put back into the road. All right, so I don't know if it's easier if you know this, you pass it around there.
Yeah, why don't you just leave them and all separate them out?
That's very important to do it. Okay, got 1, 2. Raise. Cool. And this little flower here says that use of recycled asphalt reaches new high. So what happens is if you don't recycle it, it ends up in a landfill somewhere, just ruining the earth. So if you recycle it, it gets put back down as either road base or under a sidewalk or something important. So this is easy for me to pass out, not for pieces. You won't see that later.
Thank you, Rick.
Okay.
This has the testing results where it's reclaimed aggregate and it's been passed as a DOT. This is the actual testing and these as well. And that's the actual testing of the material after you process it. And ironically, to get it to pass, to be a road-based material, if there's too much asphalt, it doesn't work. If there's too much concrete, it doesn't work. It's almost like a recipe. You need 45% concrete, 45% asphalt, and 10% actual stone. And it makes the perfect mix with like almost 100% compaction. And the last thing I want to show you is someone was at our own town's transfer station. He had like an old piece of sidewalk and they said, you can't bring that here. You must bring it to the woods.
Oh, thank you.
Oh, that's the, oh, almost.
Think you guys actually saw this last time, but very proud of it because the piece of it going out of a very expensive house and put down the driveway. That is again, that very same material. Recycled concrete, asphalt, 10% rock. Makes a great natural driveway, or you can pave over it or whatever, because again, it's been approved for sub-base. So, with all of that being said, is there any questions? Everyone's good?
You want to ask a question?
Well, do you want to go ahead with your comments first? I think we'll hold off, let Deb,
Okay.
go. Thanks so very much.
You're welcome, thank you.
Good, yep.
Okay, I'm not going to go over all of the history. All of that was in my staff report. I just will note that the renewal that happened in 2022 was appealed. It is not yet settled. Also in the packet, you'll see a letter from Attorney McCousher asking that the hearing be canceled, citing one of the sections in zoning regs that was reviewed by the town attorney, and his feeling was that's the hearing could continue on, that it applies to a special permit that has been appealed, not necessarily a renewal. So I'm sure you'll hear a bit more about that later. Also in your packet was a complaint log, and the complaints, the dates, and how they were resolved. with regards to the new pile that is showing up on this plan, the stumps, compost, whatever it is. We received that plan this afternoon, and I do want to review that with the zoning official against the conditions of the special permit. So I'm suggesting you keep the hearing open so that I can provide that review to you. Yeah, again, I'm not going to go over all the history, so
Okay.
that's all I have.
Great, thank you very much. Okay, at this point, I guess we'd like to open it up if anybody from the public would like to say anything. If you could say your name and address, please.
Yes, my name is Edward Coucher.
Can you talk into the microphone, please?
Oh, sorry.
Because we're recording this, so
Sure.
thank you.
My name is Edward Coucher. I live at 48 West Elton Avenue in Groton. I represent David Wakis. There was an appeal mentioned earlier. And I think you've all seen the letter that I sent to the staff. Which, I want to express my concern that this appeal, if you look at the docket, it's gone on for quite a while. And the court is reserving decision, meaning it's heard all the argument, it's gotten all the briefs, so we're awaiting a decision in it. And I wanted to urge you not to act at this time, because I'm afraid it would interfere with the process the court is involved with. But particularly because I cited your regulation that extends the time that a special permit is in effect. If it, in this case, it's a 3-year duration for this special permit. And your regulation, which I cited to you in the letter, states that that period of time will not run until any appeal is finally disposed of, which, we're in the process of doing now. And I just want to remark that I don't see there's not a chance of the permit that's in force now expiring. I didn't hear anything about any necessity for having this hearing now. Just give you a hypothesis. If this, let's say this was a new special permit and there was a use or some use of property that was approved, but it was stalled because of an appeal, that would be one thing. But I did, the operations that are going on the property that is at issue are still continuing. There hasn't been any interruption of what they're doing on the property, which, our appeal involves whether or not that's proper under the zoning regulations. That's another issue. So I just want to make the point that there's no reason to be renewing a permit that hasn't even run yet. And I'm urging that on you for a few reasons. And a primary one is that you're the defendants. I mean, you're not individually, but the commission is a defendant in the appeal. And by taking unilateral action like this, if you were to, for instance, if you were to approve the renewal of this permit, that, I think would only be appropriate if you had a decision of the court telling you whether, in fact, the court could rule either way. I don't know how the court's going to rule, but in the case of, let's say the court denies our appeal and holds for, the zoning commission and the Whittles and who are a participant, then their special permit would run for 3 years. So, on the other hand, if you were to grant this special permit now, that has an effect on a pending case. And I'm concerned. I actually submitted a request for a conference with the judge who was deciding the case, because I feel he needs to know about this, because this could, potentially nullify, even though for instance, if he decided that the operations on the Whittle property are not allowed under zoning, and yet you give another special permit, that would be inappropriate. We'd have to file another appeal, I suppose. I mean, this creates a number of different issues for us that I think are unfair and are probably ill-advised. So I did, I mentioned these things in my letter to you, But I'm very concerned, and I've actually told the court in my request for a conference, I'm gonna ask for sanctions for, if you go forward, if this goes forward, I'm gonna ask the court to consider sanctions for, depriving my clients of due process for interfering with the court's administration of justice. So and I'm only telling you that because that's how concerned I am about any action right now in the light of the appeal that's pending now for this very same permit to renew it, I think would be defying the court's jurisdiction, as I said in my letter. I do have some documents I want to provide you, and I'll just remark on them as I go through. I only have one copy of each, so I would like to submit them for the record as exhibits, and I'll describe what they are.
That's your only copy of the document?
Bryce, do you want those?
Yeah, we should go over it to
Yeah,
staff.
yeah.
And I'll get it out to them.
Sorry.
No, it's okay.
Thanks.
Just with respect to what you've been presented tonight in terms of the presentation by Attorney Londrigan, you have materials from your staff. There's been other materials submitted to you, and I just wanted to review some of it. For instance, the staff summary sheet. History in the section of history, and this did start in 2007 when the zoning enforcement officer Quinn issued a cease and desist for non-permitted uses. This has been prior to zoning, if you had an operation of any kind that existed before zoning, then it's grandfathered. So he had to, determine what was in existence before zoning, and then what he called the non-permitted uses, which we, believe are what our issues are with the property. And so he issued a cease and desist. There was a lot of litigation involved, but one thing that I think has been misrepresented to you, I think Attorney Londrigan submitted a copy of what he calls a stipulated judgment in 2011. There was a appeal by the Whittles at that time to the Zoning Board of Appeals. In the course of that, there was a settlement agreement presented to Judge Devine, and I believe that it's in the record. And I have a copy of it. And at the end of it, if you just look at that document, it says stipulated granted as a judgment of the court. However, that judgment was vacated by Judge Devine. This settlement, so-called settlement agreement, if you want to call it a stipulated judgment, it's not, but in any case, it's titled settlement agreement. That was signed by Judge Devine on May 12, 2011. One of the documents I provided to you is an order later in the case in which he, on March 13th, 2012, he entered, the judgment entered on 5/12/11 was entered in error and is vacated. Now, this was presented to your commission the last time I was here, in the documents provided by the applicant, as if that is a settlement agreement that is in force. And I noticed in the copy that was submitted to you in the record in this occasion, there was language in it highlighted which Attorney Londrigan is referring to as allowing the import of material to the site, such as rock and other things to be processed. But the settlement agreement has no effect. It never was a judgment of the court. There was also one of the documents I presented to you was the decision of Judge Chu in the Turner versus Town of Groton Zoning Commission. It was an appeal by Mr. Turner. He was a neighbor, lived adjacent to the Whittle property. And it's an extensive opinion, but in that opinion as well, on page 8, he remarks that I should say also if you read the settlement agreement that has been submitted by Attorney Londrigan, it says that, okay, this will be approved, but it has conditions. One of the conditions was that the Whittles have a special permit by a certain date. And it be approved, and that didn't happen. So in the Turner case, on March 13th, he states, and it's again, I provided you the copy of the court's order. He says on March 13th, 2012, Judge Devine entered the following order. The judgment entered on 5/12/11 was entered in error and is vacated. He explains in the body of the opinion, which I submitted to you, that the reason was because the conditions for approval of a special permit and recording by, I think it was sometime in 2012, did not occur. So he vacated the judgment that he entered on the settlement agreement. So the settlement agreement, again, is being presented to you as if since 2011, the Whittles had been allowed to import material to the property and process it, you know, concrete, what I've seen is construction debris, asphalt. That was not ever enforced. It was never approved by the court. It's not in effect. So I think you've been misled, and this again is an effort to mislead you about what the actual parameters of this special permit are.
Okay, could you try to come to a conclusion on your remarks? Because
Well, if you just allow me to just go through this a little bit further, because there was also like, you know, the ultimate, the special permit that is before you for renewal is number 321. That was finally, you know, agreed by the commission, and I provided you with the motion of the parties, which was the Whittles and the Town of Groton Zoning Commission at the time. And it outlines what the settlement is. There's nothing in there about importing material to the property. In fact, if you look at it, it has one copy of, I think, the settlement agreement, and it adds language, but then there's a clean copy of it, which became special permit number 321. And I've also provided you a copy of that because it's not in the record for some reason. But again, the special permit number 321, which is being sought to be renewed now and is the subject of our appeal, states permitted uses generally. Per 5C of the settlement agreement, imported materials shall consist of fill only. It shall not include hazardous waste or construction debris. Fill, you know, all these things are issues on this appeal. So I don't want to, you know, obviously, you know, you don't want to hear the whole history of the case. But these are the issues that the court is considering, whether what is being brought to the property constitutes fill, which I think fill is, you know, organic material and other things. It also says on the same page in paragraph 5, the provisions of paragraph 5C of the settlement agreement, except for the last sentence thereof, shall not apply to this special permit number 321, which again is fill only. And there's nothing in the special permit, I hope you look at it, because there's nothing in there that allows for any importing, any delivery, any deposit of any material other than fill on the property. And as you've heard described to you, there's asphalt on the property, there's concrete being brought in there, it's being processed. None of these things, these are industrial uses. So none of these things are permitted under the permit that you're being asked to renew. And these are all subject to the, you know, to the court's decision on appeal. So again, one other thing I just wanted to remark on in the, excuse me, in the summary that the staff prepared, there's a remark in there in which it remarks on the letter that I provided. And it's somewhat hard to, you know, it's somewhat difficult to understand what he's saying, but he's essentially saying, well, you can go ahead with this because we didn't appeal the last renewal of special permit number 321. And that's exactly what we did. So I provided you the application last time that was presented in 2022, which we're appealing, states that it's for the renewal of special permit 321, and that's the application of the Whittles at the time. And the other document I provide you is the administrative appeal. It's sort of the complaint on the appeal, which makes it very clear, we're appealing the renewal of special permit 321 in 2022. So you're being asked to renew the very thing that's on appeal. I think the town attorney was trying to make some distinction like this won't interfere with the appeal, but it absolutely will.
Okay.
So I hope you give that consideration.
Okay, thank you very much. Would anybody else like to make any comments? Just please give your name and address. Sure.
My name's Kurt Hayes, 10 River Road, East Lyme, Connecticut. I own a small dumpster company, Hayes Dumpster Services. And we haul a lot of small dumpsters, 10, 15-yard dumpsters into like Groton Long Point, out of Groton Long Point, Noank, a lot of areas where people are getting rid of, they're either demolishing their houses and getting rid of concrete and asphalt. And I bring it to Rick. It is clean fill, doesn't have any garbage in it. If we were to take it to the dumps, CWPM or whatever, they put it on a rail car and it goes off to a landfill in like Pennsylvania or an old mine or something. It's very expensive. They charge everything by the weight. So, this is an alternative. Gets recycled and used for, driveway base and stuff. We use it also. That's it.
Okay, great, thank you.
Yeah.
Would anybody else like to make any comments? Okay,
Yeah, Dan Gaddis, 177 Yetta Road, Mystic, Connecticut. I've known the Willows for over 60 years. I watched the kids grow up, I watched Rick grow up. Everything they do, they work so hard, they apply by everything, they do what's supposed to do. There's no trucks coming down Yetta Road anymore, they all go on the other side. Nobody complains, everybody's happy. If you need something, they're for you. And to be able to come, the stuff that they take and they dump off over there to be recycled, that's stuff that, like this gentleman right here with the dumpsters, they gotta get rid of it somewhere. Instead of sneaking over, digging a hole and bury it, they bring it so you can recycle it. And we can use the recycled materials, don't do what we do with our garbage. It's all hit run, no matter what you do. But when it comes down to the argument about the permits, it's the same guy every year complaining. If you don't like it there, move. Ricky Whittle will buy your house and buy you out. What do you want to do? This will end most of that stuff anyway. But I just don't. Why do you have such an endeavor against these people? I don't understand it, and I never will. But if I ever put a housing project in there, I'm moving. It's the name of the game. It's such a beautiful road, and I hate to see it go on. But I hope the Whittles do good. Thank you.
great, thank you. Anybody else like to say anything? Okay. Oh, yes, sure,
I'll be.
it's your time.
Thank you. I'll be very brief. I just wanted to address a few of the items that Rick McCutcheon mentioned. A lot of it is legal, a lot of it is for the town attorney, a lot of it is for the court to decide. Whether or not you can go forward with this and their claim that you cannot, I respectfully disagree. The fact is that Mr. Wakes appealed the 2022 renewal to the Superior Court, and that did not stay the approval given by the commission back in 2022. In fact, Connecticut General Statute explicitly states that an administrative zoning appeal to Superior Court does not stay the decision of the commission whose decision is being appealed. So to argue that there's been a stay in term for the last 3 years since 2022 is inaccurate and in contradiction of Connecticut general statutes. All right, very simply, the commission's decision in 2022 was appealed by Mr. Wakes. No automatic stay was put in place. He could have asked the court for a stay. He didn't, never did. So the approval was valid. 3 years have gone by. We're here in 2025. To take Attorney McCoucher's logic to its conclusion, the commission wouldn't want that, because in terms of what he's arguing, we don't have to come back and see you until 2028. If I heard him correctly, our 3 years has not been running this whole time. A court decision is made today. Now our 3 years starts running, which means we wouldn't have to come back to see you for 6 years. You wouldn't want that. That's just illogical. It makes no sense. There's no legal rights being deprived by the filing of this application. If Mr. Wakis wants to take an appeal, he has every right to take an appeal. If he doesn't agree with any decision, just like he did in 2022. And the 2022 appeal may become moot based upon what happens here, but we have every right to make the application and you have every right to hear the application. And to allege in his letter that the commission is being encouraged by Attorney Londrigan to circumvent court jurisdiction to avoid judgment in the decision to approve special permit 321. Issues of collusion with the applicants for that application, the intentional deprivation of due process rights is unavoidable if you proceed. I don't know where this is coming from. That is just taking it to an extreme. There's no collusion between myself and my client in this commission, and I don't think you believe it either. But it was stated in public, and so I'm going to defend ourselves. Now, in turning to some of the other arguments put forward by Attorney McCousher, non-permitted use is never approved. You'd have to ignore the court order and the stipulation from 2011 from the ZBA, which says that the non-permitted uses are allowed. Attorney McCousher, Judge Devine vacated the action between and withdrew that stipulation. Well, he tells you half the story. The other half of the story that he doesn't tell you is that the judge withdrew or vacated the stipulation because the agreement with the ZBA and my client was that the appeal would be withdrawn. That's the way it was going to resolve. But the stipulated judgment remains a contractual obligation between the ZBA, the town, and my client, and it was the basis for going in to get special use permit 321. And so it's incorporated into the special use permit. So Judge Devine didn't vacate and throw that stipulation out. And if you really want to argue about some sort of estoppel issue, the town attorney, the town, this commission, my client, we've all proceeded as if the non-permitted uses, all those stipulated judgments, all those orders of the court are in place and we've been going along. And now all of a sudden, Attorney McCousher knows that it's all a house of cards. That's just not true. I've lived this case for 18 years. You've lived it for 18 years. The town has lived it for 18 years. Reference to Judge Colchu's decision being vacated or being upheld and what he said in that. Again, what Attorney McCousher fails to tell you is that Judge Colchu's decision was vacated. There was an appeal to the appellate court. The matter resolved. It came back to Judge Colchu. He vacated his decision. It's on record that that decision no longer exists. A matter was settled. It is true. Other than that, we have nothing further. We think it's very clear. No issues with obviously keeping the public hearing open so you can review the plans that have been submitted. Thank you for your consideration. We'll see you at your next meeting.
Thank you. Hey, anyone else?
Let's just say just a couple words.
Yeah.
No, the applicant gets the last say. If I have
Is that
the
right?
opportunity to say something.
I don't know.
Yeah, you know,
And I don't know if you guys have any questions.
The applicant goes, and then goodbye.
Hit the hammer.
Just with respect to the Turner case. That case, Judge Chu ruled in favor of Mr. Turner and found that the uses that you're being told are valid were not valid. It was appealed to the appellate court. It was settled by the Whittles buying Mr. Turner's property. It wasn't vacated. It was settled.
Thank you.
Respectfully disagree. I was in court the day that Judge Colchu vacated his order. I don't remember seeing Attorney McCousher in court that day.
Thank
All right.
you. All right. Good. And was anybody else have any questions?
Have we,
So we're going to continue this.
yeah, just,
Yeah.
have we heard from our town attorney?
We have, I mean, I don't have anything in writing at this point, but I have talked to him about Attorney McCousher's letter. And his opinion is you are good to go forward with this application. You have a valid application, you have a fee, you have a plan. You can't just decide not to have a hearing or cancel a hearing without consequences. You know, you have to open the hearing within X amount of days by state statute.
Right,
So
Right.
that's very important, Deb, if I can just pick up on the back side of that. So the town attorney has not put anything in writing.
No,
And if we go back to the town attorney for this in future, we'd love to see that in writing.
Mm-hmm.
But it's very clear that we have an administrative action here, this
Mhm.
evening, right?
Yes.
So we don't have a legal action. Our legal advisor to this commission has said we should move it. We
and I will
can-
get that for you for the next.
That would be
hearing.
great. Thank you.
I mean, if it's getting continued, would we be able to have
I'm
it?
sorry, you're not allowed to.
Yeah.
Thank you.
No, the hearing's open. She can talk.
What's that?
It's only when it's closed
Right.
that,
Oh,
the
my
alternates
my
get it,
apologies.
yeah, there we go.
If there is a potential continuance, would we be able to have it before we close this hearing in writing?
That's my goal.
No, oh,
Yes,
okay.
absolutely.
Oh, okay, thank you.
Yes, so anybody else want to say?
No, that's it. We're waiting for that.
Okay.
And then I need to
determination of the-
review this pile, right, with the zoning.
Okay.
official.
Is that-
Exactly.
Okay, would you?
I just
like
wanna make
to-
sure it's- So it's additional material that was not shown on
Right.
previous special permit plans. I want to make sure that it doesn't exceed the limit of fill that comes in, and the height does not exceed what was required in the special permit.
But-
That's really limited.
Well, I thought I heard something about 5,000 cubic.
That's for DEEP permitting for a compost.
Oh, so it's-
That's
We're
not
not-
you.
not
But
there.
this
No,
is,
that's not you.
but this material that's shown on a new map is essentially organic material.
I know that. Yep.
It's
that-
not what I would consider earth products or rock or anything. like
Again,
that.
I'm going to talk to the assistant zoning official about it, and probably ask for additional information from the Whittles as to where it actually came from. Was it imported? Is it all from the site? All of that we need to review that to make sure it's consistent with special permit
Right.
321.
Okay. And if
Okay.
but I mean, we went through this 321 for a long time and
Mhm.
I was here for all that and I didn't think it had anything to do with organic material.
Right, but there
So-
is, in the section of 321, which was in your packet, by the way, so you can
Yeah.
look at it there. The section that describes the uses that are allowed.
Yeah.
3A, within 3A, it says only fill can be brought onto the site. No definition of what fill is, right? So again, I want to know, I'll be talking to the Whittles about where the material came from. You know, is it fill that's been brought on? Is it actually just stumps from the property?
Okay.
Yeah,
Okay.
we just want to make sure it's consistent.
Let me ask a question of an attorney.
Because it's a farm for
Sorry.
I know.
crying out
Oh,
loud.
and
I think they
they-
have
it's still
organic
open.
material.
So, but I was going to I asked for a motion
Okay,
to,
I'm fine.
and we could do it maybe next time if we had a chance to read more of the things too, so.
Are we-
everything.
Continuing?
Yeah, so.
Please.
we Need a motion to continue?
I would make a motion to continue the meeting to
14th, October 14th.
And a second.
Second.
Thank you. All those in favor say aye.
Aye.
Any opposed? Or abstain? Nay? Okay. One nay. 4 yeses.
Got it. Okay, thank you.
Great, okay. So now
Okay.
we have the minutes next, I believe.
Right. The next thing obviously on your
Good.
agenda is consideration of public hearings, but you have not closed the hearing.
No, we haven't.
So there we
closed
are.
it. No, exactly.
Right.
So, yeah, approval of minutes, so. Let's see, would somebody like to make a motion to approve the minutes?
So moved.
Have a second?
Second.
Okay, any comments? Well, I have a few comments. Once I find the minutes. Does anybody else have any comments? Pardon me. Well, I'm delaying this myself.
A lot of receipts.
Yes, there are. Nope. Nope, nope, nope. The problem with these iPads,
Page 81.
is it 81? Oh, okay, thank you, that's helpful. All right, so, strategies, let's see. I think on page 82. Thanks. 80 on the second paragraph.
The one that starts ease
Ease
traffic.
traffic,
Okay,
yeah.
yep,
When you get down to the third line from the bottom where it says examples are transit passes, carpools, parking. And maybe put in there and for people who bike, showers at work
Mhm.
or something. Just a minor thing. Let's see. I think that's it. Okay. So all those in favor? Say aye.
Aye.
Any opposed? Okay. Passes the minutes. Next. I have to go back to the topic. I should have printed those out. That's what we did. Okay. All right, now public communications. Anybody else?
I just want to note that we did receive a resignation from Clint Kennedy.
Oh, yes, yes, I meant to.
Resigned, he's just too busy to
Good.
dedicate
Yeah.
time for these, yeah.
But he did write a very lovely note and thanking the commission. He enjoyed his short time. Okay, and then Sweeney correspondence.
Right, so Attorney Sweeney has asked to schedule a workshop with you to talk about open space subdivision regulations. We had talked, he and I had talked about October 14th. I will let him know that the public hearing has been continued, and if he's not interested in waiting around until the public hearing is done, it may be the second meeting in October.
At that public hearing, will there be more presentation? Will it
It's
just be the
entirely,
information?
it can be more presentation, it can
because
be
we
more
haven't
public
closed it.
input, that's
right.
right.
Okay.
'Cause
That's
it's
right.
open.
So I'll talk to him about it, and see which October meeting he's interested, but this is workshop, talk about zoning regulation amendment. Just to
Just
get,
similar to what he did previously. Yeah,
exactly,
okay, that's
yeah,
fine.
exactly.
And
Seems
does he,
like it-
is he thinking of one particular property for this? Or
As he noted in his plan, it's a property his client has on the corner of Noank Ledger and Sandy Hollow.
okay.
Yep.
Can I
Thanks.
ask one question too, sorry, Sue?
Sure.
So I found this very valuable, at least what we did on
Mhm.
117. I mean, the ability to have that conversation, I felt really provided a very deep perspective and analysis of potentially what we could do, a very positive thing.
Mm.
And so this one appears to be the same, right? But there's no issues on the approach as far as that's concerned.
No,
Okay, and then my only feedback then, because there's no issues on it, is I find it to be a very positive
Mhm.
collaboration with applicants.
good.
Yep.
potential
So
applicants.
whatever you say to him during that meeting is not binding.
Great, that
So-
was my last question.
Yeah.
Okay.
Yep.
Good, great. Thank you.
That's a political. It's
Yeah.
Sandy Hollow and Noank Ledger.
Right, Sandy Hollow and Noank Ledger Road, that's correct.
Okay. Now, special permits,
None.
subdivision, site plan, old business, new
New
applications.
business.
I don't know if anybody else had public communication. I don't, okay.
Oh, no.
I don't know if there's anyone online. Okay.
Oh, right. I always forget to look at.
No
the people.
hands.
So new applications?
Right, we've received a new special permit application for a bed and breakfast on Noank Ledger Road. We're going to be scheduling a hearing in October.
Okay.
Yeah.
And then there was a town of Stonington referral.
Right, it looks like it's a special permit to add liquor sales to the Mystic Fish Camp restaurant that's recently I opened. Yeah.
Does anybody have any issues? Okay. Very good. All right. So a reported share. I don't really have anything to special to report. Anybody in the commission?
Yes, I do so.
Okay,
So, my issue is that I have an update regarding my Connecticut human, rights complaint. Which has now moved along into two areas. The town, through a separate attorney organization, argued the points where my point, of course, was that we have a pattern of discrimination against protected individuals. And my legal team has been very specific that the pattern is what creates the problem, not that they would have to say individually, Kevin, you're old, or whatever along those type of lines. So we find their reply without merit, and that we will move to a mediation session prior to this being held in a much more formalized fashion. And the mediation session basically asks is, Kevin, what are you willing to live with? And then ask the town is, do you choose to go along with the mediation that Kevin provides? And if so, it ends the case if we agree. There has been a town council person who accused a different person in Connecticut Human Resource of running up costs of almost 21,000 when in effect it was $938. So I just wanted to state here that it's not in any way my choosing to continue this case if we can simply go to mediation. And that's what I hope takes place. If we do choose probably within the next 30, 45 days in that mediation to end it, it's all good. If not, the other people who are named as part of the commission who went through some of the challenges of Robert Rules of Order, et cetera, will most likely be contacted as far as this is concerned. And that's it.
Okay, thank you for the update. Okey doke. Report of staff.
Just want to remind you of the October 9th meeting.
That's right.
On the missing middle project. Again, it's not a planning and zoning commission meeting, it's not a planning and zoning commission project, but that information will certainly help inform your work with the OCD.
Great, okay.
Anything else you want to add?
No.
And that's 2025 data.
2025 data, I mean, there's retrospective data part of it, but it's looking at the 2025 forward to 2035. So again, looking at that 10-year time frame.
Yep.
And then, yeah, be on the lookout for a website associated with the Missing Middle project. And again, the guided walks, which I think we're really excited about, but we gotta nail the date down.
There was a article in the New York Times today, but they had some, I mean, if you Google it, I think it was the governor, I remember it's right. They have a new plan where they have kind of like a prefab type house that would satisfy some of the, you know, more middle market-ish type things. And when you look at the design of it and the inside and everything, I think it's quite interesting because I think it's one of the better designs I've seen, you know. It doesn't look like a modular home per se. It's quite open, but just, you know, it's another thing. Maybe if you have time, take a look at that article. It's a different approach by a big state, so.
They need to go back to where you can buy a house out of the Sears Co.
Yeah.
Bringing those back.
I'm really surprised at Amazon.
Well,
I mean,
Yeah.
you can buy Amazon,
Yeah.
you know, anything, and I'm
Yeah.
surprised, you know, it's like,
They have a house.
yeah,
They have
Elon
houses.
Musk.
do they?
Yeah, they have houses.
Really?
Can I ask a question of the staff? So what's due from us regarding POCD? So I just gave something to Shannon today.
Yep.
And I thought I had another deliverable, but what I gave her was the document where you check particular support
Right.
levels. Is there anything else pending that's,
Nope, that is right. That's in advance of next Monday's special meeting. Where you're going to be reviewing the chapters on housing, land use and economic development, the policies and strategies. So, you know, to that end, feel free to fill out those forms, get them to us, fill them out, bring them to the meeting, but just be prepared to discuss those strategies and policies. So thank you. We've already forwarded that on to Horsley Witten.
oh,
Great.
I missed something else. I thought I baffled.
And that will, okay, you will be getting an agenda for that meeting later on this week, and you'll see those again attached
So,
to the meeting.
this
Yeah,
doc-
that is
Yeah,
exactly.
so send it to Shannon.
Yeah,
And it
absolutely.
fills out, as long as you save it, it fills out electronically,
Yep.
so you can do it online.
Oh, I was started to do it and then
Sort of.
I did it on paper, but I'll do it electronic.
Whatever.
You gotta save it first. That's the issue, right?
Save it for.
Save it, right, to a PDF or whatever. you
Okay,
save it
all
to.
right, that makes.
Then you mark it, then you can attach
Yeah.
it.
But if you wanna,
You
Yeah,
want
but I'm
to,
having
it's
difficulty.
Yeah.
I have so much paper here.
I
right
know,
now.
I
It's
know,
like Things got
I know.
mixed up.
So, application update?
any
Anything?
questions?
Okay, ASP report
Again, and I will note, we have approved a couple of ASPs for prefab ADUs.
Oh,
So
okay,
it is working its way this.
interesting.
Yeah.
Any specific part of town?
No, one in Mystic and then one off of High Rock Road, Thomas Road area.
And if I can just
Yeah.
expand on that, the consideration of the amount of site work required, those costs get pretty high, pretty quick, right? The soft costs and some of those hard
What, on
costs.
the on the accessory dwelling?
Yeah,
On
the
the prefab,
prefab?
like
That is a prefab? that
Yep,
goes-
yep. So I don't know
That's
that we've
interesting.
seen many others, but the cost savings.
Really? Okay.
right, you look at the cost
Huh.
and it's only for the prefab ADU.
Yeah.
It doesn't include the hookup to sewer or the site work or the foundation or, so.
What kind of numbers are there? What does one cost?
Oh, gosh, I mean, they're
What's-
probably netting out to like 300,000.
Yeah, exactly, yeah,
Really?
yeah.
How many square feet is that?
300,000.
It's gotta be under
like
1,000, under 1,000.
I think the ones we've seen are like 600.
Yeah, well, that's not, you know what, I got a friend and I was asked, and right now he's doing one up in Hartford and it's $250 a square foot.
Yeah,
So-
yeah.
Yeah,
Wow.
yeah, exactly.
But if you look at the numbers though, like you can borrow that amount of money and make it work as a rental.
I
mean,
think
you
they
could.
use HELOCs a lot and stuff like
But
that.
the middle housing, that they call that out, the right price, is that usually you can't get a mortgage for that ADU. Usually you have to come up with the full price.
Right.
That's my understanding.
Right.
It's probably true.
There are mechanisms, I
Right.
think they're exploring out Potter, Fannie Mae, Freddie Mac, FHA to borrow against expected rental income.
Yeah.
Be able to do that more effectively for ADUs, but I don't know where that.
Business, so.
Yeah, I just don't know where that is right
You
now.
wouldn't be able.
So you may hear more about that on the 9th.
Yeah.
It seems like I'm missing.
Like, was very interesting.
I know.
Well, it's very interesting.
Part of the benefit of doing it that way is not necessarily the total cost, is the speed of it, because by the time you've finished the pad or the basement, whatever, then these units arrive and get plugged in. So the whole thing can happen in a matter of a month and a half,
Yeah.
and you can have your house complete.
That's right.
Plus you would be
And-
looking at the same
and-
piece of property, so the bank would essentially be leaning the main house and the ADU at the same time, I would think. It's the same property.
Read the documents, very interesting, right? I never even would have known that, right?
Well, okay.
It needs a new banking product.
What a motion to adjourn.
So moved.
Second. All right, thanks, everybody, for all your work and time. Very interesting.
5, 6.